Our Business from the Bench segment tonight, the Washington Redskins will keep their name. The Supreme Court struck down a federal law banning the registration of disparaging trademarks on Monday, saying that such a law violates the right to free speech. The Patent and Trade Office had canceled 6 of the Redskins' trademark registrations on the grounds that their name was offensive to Native Americans. With me now to break it down, legal affairs reporter for the Daily Caller News Foundation, Kevin Daly. Kevin, good to see you.
Hey Liz, always great to be with you.
All right, Kevin, let's rewind just for a minute to make sure that all of the viewers know exactly what law we're talking about here. So on the books for several decades, as I understand it, has been a law that the United States government won't issue trademarks if there's any sort of, I guess, offensive speech or anything that could offend anyone associated with that trademark.
That's right. You're referring to the 1946 Lanham Act, which prohibits the Patent and Trademark Office from issuing any trademark which is disparaging or brings into disrepute persons or communities, living or dead. So it was that provision of the Lanham Act that was at the crux of this challenge, which was brought by a number of groups. The Redskins was one of them, but the case that reached the Supreme Court was a group of Asian Americans who formed a rock band called the Slants. They applied for a trademark with the PTO, and the PTO denied them a trademark on the basis that their name is disparaging towards Asian Americans.
Right, which is understandable given what their name is. But then the Supreme Court, I mean, tell me about their ruling. They overturned this law that's been on the books for quite some time.
They did, and they did so unambiguously and unanimously. So there were a couple of issues that first needed to be worked out in connection with this case. Whether a trademark can be considered government speech, whether a trademark is a subsidy, and we can talk about those interesting side issues if you like. But the court also, again, unambiguously and unanimously, as it has many times in the last decade, affirmed that speech which is offensive or speech which is hateful in the eyes of some is fundamentally protected by the First Amendment.
Right. Sometimes it's surprising to me that we're still having this argument, a couple hundred years later. That is literally the idea of the First Amendment. If we all agreed on things, if we all said things that were only nice, only kind, only courteous, we wouldn't need to protect the idea of speech. Everyone would support it. The idea of the First Amendment is to protect people being allowed to say rude and offensive things. That's why it was written. But Kevin, do talk to me about this idea that a trademark would constitute government speech, because, I've read a lot of Supreme Court cases. You, I'm sure, have read even more, but this seemed like an awfully weak argument coming from the defense.
Yeah, so a couple of things there. First, I would just like to address that excellent point you just made, which is just to say that it's worth noting that the Slants, the band involved in this case, wasn't even attempting to make a hateful or offensive statement. As I mentioned, this is a group of Asian Americans who wanted to reclaim the term slants for purposes of empowerment. They wanted to redefine a hateful term in an empowering way, as other minority communities have done with disparaging terms. And it's worth noting, as the court did, that oftentimes when the government attempts to play the censor, it will weaponize its laws against minority communities who are attempting to defend themselves, which is exactly what happened here. In terms of the government speech argument, the government attempted to invoke what's called the government speech doctrine and make the defense that they do not have to issue trademarks which are disparaging. And Justice Alito, who wrote the controlling opinion in this case, made very quick work of that argument. He said that if we are to consider trademarks government speech, then the government is babbling prolifically and incoherently. It is saying all manner of commercial slogans, and frankly, it is saying other offensive things because, as the Cato Institute pointed out in its amicus brief in this case, there are already dozens of trademarks that exist that use offensive terms, and in some cases, vulgarity. So if we are to consider trademark speech, then the government is already engaging in vulgar speech, and it is saying contradictory things and endorsing commercial slogans. So on that basis, it just strains credulity to argue that a trademark.
And listen, I don't think the Supreme Court justices, by the way, get enough credit for their wit. This was so funny to me when I read Alito's opinion on this, and he was the majority opinion. When I read his opinion, he was so funny because he actually wrote an example of all the contradictory slogans that we all know. Nike's slogan and Subway's slogan, all these ones that are in everyday American vernacular, and he used them as examples of, if this is government speech, this is the way that it's contradicting. I so appreciate that kind of clever.
Government is telling you to just do it. That doesn't make any sense at all.
Right, exactly. All right, talk about the subsidy thing, because the defense was also arguing that issuing a trademark is sort of like the government giving these people a subsidy, and they argued that the government, which of course is funded by the taxpayers, shouldn't be giving that money to someone who's being offensive.
Yeah, so Justice Alito also made very quick work of this argument, and he pointed out that there are some precedents which suggest that the government has a little bit of leeway in granting subsidies and that it can engage in a little bit of viewpoint discrimination there. But he quickly points out that when the government registers a trademark, there's no money that's changing hands. There's no financial support or underwriting that's granted to the item or name that's being trademarked. Therefore, this can't be considered a subsidy in the general sense because no money is changing hands here. So that defense also did not hold up well before the justices.
Nope, they made quick work of it. I don't think a lot of people had heard of this band. I think they call themselves an Asian rock band or an Asian dance rock band, the Slants. Most people, including myself, had not heard of them. But most people, I think, have heard of the controversy surrounding the Washington Redskins and their name and the attacks on their name. This ruling greatly impacts them.
Yeah, so they're probably the most high-profile beneficiaries of this ruling. As you mentioned in the intro, the Redskins were stripped of 6 of their trademarks several years ago as part of a high-profile public relations campaign against them that drew the attention of even some powerful lawmakers in Washington, Harry Reid among them. And the Redskins actually attempted to intervene in this case and become the primary party in this case. They actually threw some real shade on the Slants. The lawyers for the Redskins said, look, we're better lawyers than these guys who are representing the Slants. You're going to get better briefing from us. You're going to get better advocacy from us. So you want to take our case as opposed to their case, an argument to which the justices did not react at all well.
I guess not.
But the Redskins are certainly going to be the primary beneficiaries of this ruling, and I think it's safe to say that the trademarks which have been stripped from them will soon be restored.
Right, and really at the end of the day, the winner here is free speech. The winner here is the American people because we should be allowed to say whatever we want, even if it does unfortunately offend someone else. Kevin, thanks for being on the show. I appreciate it.